This is Michael Popok, and it must be Legal AF after dark time. Supreme Court issuing its rulings as it leaves for its summer vacation. We haven't gotten the rulings we wanted yet, but we have received major rulings, including about the use of weapons of mass destruction under appropriate gun control regulation in this country. And the Supreme Court, in a MAGA 6-3 decision, has decided that people are allowed to go buy kits to convert their semi-automatic weapons into automatic weapons, firing over 1,000 shots a minute, killing people. Remember, the bump stock prohibition. There's 500,000 people in America that own a bump stock. To convert a semi-automatic to an automatic weapon was outlawed after the mass shooting in Las Vegas, all right, in 2017. And this Supreme Court finally got around in 2024 to decide that the Alcohol, Tobacco, and Firearms Agency overstepped their boundaries in outlawing bump stocks. We talk about it on Legal AF. Take a listen.
Let's talk about the United States Supreme Court decisions from this week. Let's talk first about Garland v. Cargill, then let's talk about FDA versus Alliance for Hippocratic Medicine. Garland v. Cargill, the question in the case was whether a bump stock, which is an accessory for a semi-automatic rifle that allows the shooter to rapidly re-engage the trigger to fire very quickly, 800 to sometimes 1,000 rounds per minute, converts the rifle into a machine gun. The United States Supreme Court holds that it is not, and therefore it can't be banned under a 1986 statute which banned civilian use of machine guns. Just to give you a further definition of bump stocks, just so you know, bump stocks are a piece of molded plastic or metal that replaces the butt of a rifle and the handle closest to the trigger. The piece allows a portion of the gun to slide freely back and forth. The recoil from a shot causes the gun to bump between the shooter's shoulder and trigger finger, causing shots to be fired in quick succession. Americans bought about 520,000 bump stocks between 2008 and 2017 while they were legal, in response to the Las Vegas shooting where 60 individuals lost their lives and hundreds were injured. I know, Michael Popok, you were not specifically in that concert, but you were close by in Las Vegas that day as well. But in response to that tragedy, the ATF banned bump stocks for civilian use by looking at their enabling regulations about what they're supposed to do as the ATF. They looked at the 1986 statute that defines machine guns. They determined that they had the ability to regulate this specific bump stock, this device. And so they said, no, it's banned. And the fact that it wasn't banned before is not an admission that it was legal. It's just, as an agency, it was a new device that was around. The ATF had always said it was looking into it. And when this tragedy struck, like that happens, as tragedies happen across the country, that tragedy is an avoidable one, definitely an avoidable one that happens too frequently here. But then agencies which are equipped with this authority, with this types of authority, take action. That's the way this. That's why we have agencies, right? But the Supreme Court, which has been taken hostage by this federalist wing, in addition to their views on the Second Amendment, which they've basically held that the Second Amendment provides almost unfettered ability for Americans to have weapons of war. This case was decided on kind of another doctrine, not even necessarily the Second Amendment, but this other federalist doctrine to try to basically take down the federal government, that basically says, unless Congress specifically uses magic words, in this case specifically mentions bump stocks by name, an agency can't do anything. They can't take any action. And I'm sure if you go back to some of the other legal AFs that we've done, you've seen that this is a way the Supreme Court has struck down common sense regulations from agencies, whether they were related to COVID, whether they were related to the environment, whether they related to kind of other common sense actions that could be taken by agencies across the spectrum, saying Congress has to specifically say magic words. If Congress acts in a broad fashion and gives you kind of broad powers, that's not sufficient. It has to say the magic words. And look, we all know that Congress never does that. That's not something I wish Congress could actually act and do that. But right now you have a Congress led in the House of Representatives by MAGA Mike Johnson and MAGA Republicans who are utilizing Russian and Chinese spies to launder in false information. And then they're turning it over to Rupert Murdoch properties so they could run headlines, Joe Bribin, based on fake audio recordings that don't exist that come from Russian spies. I mean, that's the status of Congress. So is Congress going to and they're bought and paid for by the NRA and other special interests. Are they going to use specific language? So it's also kind of a gaslighting by the Supreme Court so they can strike down really important things that help the American people. But then the Supreme Court can also then say, but look, what we're saying is we're not against the idea of banning bump stocks. It's just Congress needs to act. That's all we're doing. It's a gaslighting thing the Supreme Court does. Because look, take a look at the definition of machine gun in the 1986 statute. It says, the term machine gun means any weapon which shoots, is designed to shoot, or can be readily restored to shoot automatically more than one shot without manual reloading by a single function of the trigger. The term shall also include the frame or receiver of any such weapon, any part designed and intended solely and exclusively, or combination of parts designed and intended for use in converting a weapon into a machine gun. And that's what the bump stock does. It's intended to convert a semi-automatic weapon into a machine gun-like device. And that's what was made very clear in the dissent by Justice Sotomayor, who first and foremost said, you all claim to be strict textualists. How much more textually strict can you be than what Congress said in 1986 about the parts? And then Justice Sotomayor said, today the court puts bump stocks back in civilian hands. To do so, it casts aside Congress's definition of machine gun and seizes upon one that is inconsistent with the ordinary meaning of the statutory text and unsupported by context or purpose. When I see a bird that walks like a duck, swims like a duck, and quacks like a duck, I call that bird a duck. A bump stock equipped semi-automatic rifle fires automatically more than one shot without manual reloading by a single function of the trigger. And she cites the statute, section 5845B. Because I, like Congress, call that a machine gun, I respectfully dissent. And finally, before passing it over to you, it's worth noting that Justice Clarence Thomas wrote the opinion of the court, that it was a 6-3 decision. It was a right-wing Supreme Court-led decision. The 3 justices in the dissent were the Democratic-appointed justices. The 6 justices who are now putting bump stocks in civilian hands are the Republican-appointed justices, including 3 appointed by Donald Trump. And with all of the news that's come out recently about Clarence Thomas's corruption, which we knew about before, but every day it seems there's another $1 million he's received and been bribed by billionaires to do their bidding. I think we're up to $4 to $5 million now with all of these trips that he's taken. Justice John Roberts, the Chief Justice, assigns who writes these decisions. So the fact that Justice John Roberts, even in all of this, not only is part of that majority, but giving the decision to Justice Clarence Thomas to write is also, I think, a screw you to the American people as well, and intentionally done. Popok, I know I ate up a lot of that apple in that one, so I'm going to let you talk about the other case as well, FDA versus Alliance for Hippocratic Medicine, and I'll let you take more of that one. But I know you want to comment on Garland v. Cargill as well.
I'll do it from a broader perspective. The problem with this Supreme Court is that they've spent last 2 terms with an agenda. And the agenda is to roll back administrative agencies through their interpretation of the Administrative Procedures Act. And if they don't see literal text to support the delegation of authority by Congress to the agency that's responsible for regulating in that particular area, EPA, environmental protection for clean water, education for the education department, ATF, alcohol, tobacco, and firearms for guns. If they don't see it literally there, they've taken a position through judicial activism that the agency has gone too far. We all recognize or we should recognize that government would be immobilized if they could only rely on what Congress writes, sometimes in slapdash format, throwing it together, sometimes the last minute, 5-page, 10-page pages, 100-page statutes. Sometimes they're artfully drafted, usually in consultation with lobbyists or written by lobbyists. Sometimes they're not. But Congress always delegates and expects that the real rulemaking is going to be done through the Administrative Procedures Act and by the agency that has substantive knowledge in the area, that takes in information from the industry and from consumers, that holds hearings, and that through rulemaking creates rules to implement what the law and policy that's been established by Congress. That's why we have a Code of Federal Regulation, the CFR. The CFR is this giant set of rules that when Congress talks about aspirationally, and maybe with some meat on it, about clean water or clean air, or what they're going to do about drilling or fracking or gun control, they leave it to the experts, substantive experts in these agencies, to actually backfill with the regulations. It's always been, and it always will be. We couldn't operate a government properly just relying on what Congress was generating in terms of the law, if you will. And that's why there's this is allowed to be this delegation. They are unique among the three branches. The president, occupying the second branch, operates through will, force, and powers given to him by the Constitution and executive orders. The Supreme Court is 9 people and operates through issuing orders and decisions like the ones that we're talking about on legal AF, and regulates things below them at the federal court system and through budget being allocated to them, and sets those rules and procedures for litigants and for the public, and then sets precedent and laws. Congress, Article 1, right? It has the power to do all those things, to set the law of the land, the federal law of the land, and to regulate in areas where they choose to regulate, and to oust state regulation where they find it appropriate. That's our system of federalism. In order for them to do that, however, that task of regulating all conduct and behavior effectively in industries in this country, okay, from securities to environment to education to loans to consumer protection, so on and so on and so on. They have to rely. They don't have enough hands to pull all the levers. They've got to have these agencies. This Supreme Court thinks that the agencies have run amok primarily under Democratic control. And so they've spent what seems like a lifetime, but at least the last 2 terms, including this one, trying to roll back administrative and even executive acts. Because, with all due respect, Trump actually was one of the ones that signed an executive order related to the bump stock banning as well. Even he thought it had gone too far after 60 people died in Vegas the night that I was there. I'll talk about my personal experience in a minute. So that is counter to decades of proper discretion given by courts to the agencies charged with their responsibilities because they're subject matter experts. That deference is over with this court. And you see it most acutely and most in a most depraved way when it comes to gun control. Clarence Thomas is the same person who 2 years ago wrote the New York rifle and pistol decision, which completely changed the relationship between guns and people in this country, and wrote out, much to our chagrin, I know yours particularly, Ben, the well-regulated militia language of the Second Amendment, and basically said people have the right to carry handguns, and it can't be regulated or limited unless you find a historical analogy back in the 1800s that was similar, without reference to the fact that the 1800s had a lot of things contextually that, of course, the court ignores, that we don't want to repeat. Women as second-class citizens, Black Americans, not even Black Americans, second-class citizen slaves during long periods of that. And yet we're going to go back to old-timey times to find historical precedent to decide whether a particular gun regulation should survive or not. It's so bad now that even Amy Coney Barrett, in another opinion that came out this week involving, of all things, copyright, took on the consistent use of historical precedents instead of judge-made tests to set law. She said it's gone too far. What happens if you reach a regulation where there is no historical reference? What if you're doing nuclear power regulation? Well, you can't go back to old-timey times for that. So you're just delaying the inevitable. Eventually, you'll run out of regulations in the modern world on an artificial intelligence. You can't go back and find an 1800 analog for that. And so even she's getting annoyed, yet she sides consistently, of course, with the majority. Here, you've got what looked to be, to every rational human being, except for this United States Supreme Court MAGA majority, to be the easiest way to take weapons of mass destruction out of mass shooters' hands. The bump stock, and I'll just dive into this for a minute. Total coincidence, total negative serendipity. I'm in Vegas the night of the Harvest Festival shooting. I'm there because I'm going to court on that Monday, and I came in a day early. And I'm waiting for colleagues of mine to arrive to have dinner. And while we're at dinner, we get a text from one of our colleagues who's about to land at the airport. The airport in Vegas sits alongside or nearby the open field where the Harvest Festival was held, many hundreds of yards away from Mandalay Bay, the hotel. And we get a text that there are people running onto the tarmac. And we were like, what do you mean people are running onto the runway? What do you mean? And then within minutes, we get security coming into our dining room because we're having dinner, telling us everybody's got to get up and move right now. And I had the presence of mind, and I don't know why, and I wish I didn't have to do this, but I actually looked up and said to the person, active shooter, and they said yes. So they didn't know where the shooter was at that time. They didn't know if it was happening at multiple hotels. And so they went into some sort of security plan, and they got us out of that dining room as quickly as possible. And of course, by the time I woke up, I realized that 60 people had died because a mass shooter using a bump stock attachment to a semi-automatic weapon had done target practice and killed these people. And I traveled home with people who had been shot, been grazed or had shrapnel. I got out of there as soon as that hearing was over on Monday because I was so shaken up by it. And the fact that there is not a consensus, Republican and Democrat and others, about banning bump stocks, and that you can't use existing laws the way the subject matter expert ATF did to say this conversion kit of creating and putting this piece and replacing the back handle up against your shoulder of a rifle or some sort of semi-automatic weapon, which creates an ability to shoot 600 to 700 to 800 bullets per minute. Because Clarence Thomas, relying on pro-gun propaganda as part of his opinion writing, thinks that, you're pulling the trigger 800 times in a minute. You are not pulling the trigger 800 times for a minute. And that's how he distinguished machine guns from what happened here. And that's where the walk like a duck and talk like a duck came from with Judge Sotomayor. You're not doing that. Your shoulder and the recoil is creating a mechanism that is allowing the weapon to fire that many times. And if you have a semi-automatic weapon, which is still legal, you just made it into an automatic weapon. And that's exactly what the shooter did at Mandalay Bay that night. So what you have is they've created for themselves, because we need to take on all agency work. And if we don't see it in the literal text, we're not going to allow for reasonable interpretations by the agency. This is the result. The result is between now and the time that the Democrats take back Congress and they can actually pass a bump stock law, banning law. Unfortunately, you and I are going to have to count the mass shootings using bump stocks between now and then.
And apply this logic or illogic by the right-wing Supreme Court right now. Every single agency action, unless Congress specifically used magic words and had the foresight to predict inventions in the future that didn't exist at the time it legislated, everything an agency, all the action Congress envisioned the agency to do, the agency will not be permitted to do. Bump stocks weren't created until the early 2000s. So in 1986, Congress was pretty smart. They recognized the issues that were happening, but that were on the horizon. They couldn't predict the name of all of these devices, so they described the devices that they wanted to ban. And Congress, when it functioned in a bipartisan way, did that. And they predicted the types of devices. They couldn't call it by the name because it didn't exist yet. So then when that thing came into existence, then the Supreme Court saying, well, it's not specifically mentioned by Congress as bump stock, so we're striking it down. Justice Thomas said the following: Congress has long restricted access to machine guns, a category of firearms defined by the ability to shoot automatically more than one shot by a single function of the trigger. Semi-automatic firearms, which require shooters to re-engage the trigger for every shot, are not machine guns. This case asks whether a bump stock, an accessory for a semi-automatic rifle that allows the shooter to rapidly re-engage the trigger and therefore achieve a high rate of fire, converts the rifle into a machine gun. We hold that it does not, and therefore we affirm. So that's how Thomas puts it. But take a look at what Justice Alito says, and this is what I mean with the gaslighting. Justice Alito goes, in a concurring opinion, I join the opinion of the court because there is simply no other way to read the statutory language. There can be little doubt that Congress enacted 26 U.S.C. Section 5845B, that's the machine gun ban. It says there can be little doubt that the Congress that enacted that statute would not have seen any material difference between a machine gun and a semi-automatic rifle equipped with a bump stock. But the statutory text is clear and we must follow it. He's even saying in this opinion, when Congress enacted it, they would not have seen a material difference between the exact thing, the machine gun they were banning, and a semi-automatic rifle equipped with a bump stock, because if it looks like a duck and quacks like a duck, it's a duck. That's exactly what Justice Sotomayor is saying in the dissent. And then Justice Alito says there's a simple remedy, though, for all of this. Congress needs to amend the law. That's not a simple remedy because the MAGA Republicans in Congress are cheering this decision because they're bought and paid for by the NRA. I wish it was a simple solution. I wish our government functioned and worked, but we have MAGA Republican congressmen dressing up in long red ties, showing up to a convicted felon's criminal trial and attacking a judge's daughter.
We don't blow smoke or sunshine. Nobody censors what we say. We're an independent network built here, MeidasTouch, and that was Legal AFR podcast at the intersection of law and politics. We do every Wednesday and Saturday at 8 p.m. Eastern time, and then on all major podcast platforms. Join the MeidasTouch YouTube channel. Help them get to 3 million free subscribers. We're the network we're building with our bare hands and with your bare hands as well. And if you like what we're doing, take that clip, send it off to friends and family, invite them to join our full-length podcast on Wednesdays and Saturdays. We curate the top 4 or 5 stories at the intersection of law and politics, and we bring it to you the only way we know how, without blowing smoke or sunshine, as practicing lawyers in the courtrooms that we talk about. So until my next hot take, until my next Legal AF, This is Michael Popok reporting. Heary, heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.